The fight over suppressors just took a turn that no gun owner can afford to ignore. For years, the National Firearms Act has forced Americans to pay a $200 tax, file mountains of paperwork, and wait months, sometimes close to a year, just to legally own a device designed to protect hearing and improve safety. Now, for the first time, a federal appeals court has declared that this licensing scheme is presumptively constitutional. That ruling came out of the Fifth Circuit in a case called United States v. Peterson, and it has gun rights advocates sounding the alarm. The court essentially treated the NFA's suppressor process as if it were a shall-issue permit system, like those used for concealed carry. Groups like the Firearms Policy Coalition say that's a dangerous distortion of the Supreme Court's Bruen decision, and one that threatens to lock suppressors into federal regulation for years to come. So in today's breakdown, we're going to look at what actually happened in the Peterson case, why the court sided with the government, and what this means for the Second Amendment going forward. Because, make no mistake, this isn't just about one man in Louisiana. It's about whether Americans will ever be free to own suppressors as ordinary firearms accessories, or whether the government just found a new way to keep the NFA alive. The case that set all this in motion is United States v. Peterson. George Peterson was a firearms dealer running a small business out of his home in Louisiana called PDW Solutions. In 2022, after months of surveillance, ATF agents raided his property. Inside a safe, they found a suppressor, homemade, built from a kit, with no serial number and, most importantly, no registration under the National Firearms Act. That single item triggered a federal indictment. Peterson was charged under 3 separate sections of the NFA: possession of an unregistered firearm, failure to register, and violation of the tax scheme tied to suppressors. On paper, it looked like a straightforward NFA bust. But Peterson pushed back. He filed 2 key motions. First, that suppressors are protected arms under the Second Amendment, making the entire NFA licensing system unconstitutional. And second, that the search itself violated the Fourth Amendment, because the warrant used to raid his home was based on weak, questionable information. The district court denied both motions. Facing the reality of a federal conviction, Peterson entered a conditional guilty plea, preserving his right to appeal those constitutional questions. That appeal brought the case to the Fifth Circuit Court of Appeals. And that's where things took a troubling turn. On August 27, 2025, the Fifth Circuit upheld his conviction. The court assumed, without actually deciding, that suppressors might be arms under the Second Amendment. But then it sidestepped the core issue by declaring that the NFA's licensing scheme was presumptively constitutional. Their reasoning? They compared it to a shall-issue carry permit system, the kind the Supreme Court said could survive under Bruen. In other words, the court treated an 8-month wait, fingerprints, photographs, a background check, and a $200 tax as if it were no different from a simple permit application with clear rules and quick approval. That leap in logic is what groups like the Firearms Policy Coalition immediately condemned. To them, the Peterson case wasn't just about one suppressor. It was about a court giving the NFA a constitutional shield it's never had before. When the Fifth Circuit upheld Peterson's conviction, their reasoning raised more questions than answers. The judges leaned heavily on the Supreme Court's 2022 Bruen decision. In Bruen, the court struck down New York's restrictive may-issue concealed carry system, but noted that shall-issue systems, where permits are issued if objective requirements are met, could be acceptable. The Fifth Circuit took that small caveat and stretched it beyond recognition. They said the NFA's suppressor process, fingerprints, photographs, background checks, paperwork, and a $200 tax was close enough to a shall-issue system to be presumptively constitutional. The problem is obvious. Buying a suppressor under the NFA is nothing like applying for a concealed carry permit. In most states, a carry permit background check can be processed in days, sometimes weeks. Under the NFA, wait times historically stretch for months, often 8 months to a year. On top of that, the tax isn't a nominal administrative fee. It was deliberately set in 1934 to be prohibitive. Adjusted for inflation, that $200 stamp was equivalent to thousands of dollars today. Calling that a shall-issue system is like calling a toll booth a border wall. It ignores the burden entirely. The court also brushed aside Peterson's specific situation. They argued that since he never even applied for registration, he couldn't prove the law denied him his rights. But that misses the point. Peterson didn't apply because he would have been forced into an unconstitutional process in the first place. Saying he lacked evidence is like telling someone they can't challenge censorship because they never submitted their speech for government approval. That's why the Firearms Policy Coalition immediately blasted the ruling. They called it deeply flawed and dangerous, pointing out that it opens the door for courts across the country to rubber stamp the NFA as constitutional without ever grappling with the reality of its burdens. By accepting the government's framing, the Fifth Circuit has effectively given the ATF legal cover to keep enforcing suppressor restrictions, no matter how outdated, costly, or inconsistent with the actual text of the Second Amendment. The Fifth Circuit's decision doesn't just affect George Peterson, it sets a precedent that could ripple through every state in the country. By labeling the NFA's suppressor scheme presumptively constitutional, the court has given federal prosecutors a powerful new talking point that suppressor restrictions have already been blessed by an appellate court under Bruen. For everyday gun owners, that means the barriers remain firmly in place. If you want a suppressor, you're still stuck with months of waiting, fingerprinting, photographs, background checks, and paying a $200 tax. And if you decide to build your own, or skip the paperwork, you're risking felony charges and federal prison. The message from this ruling is clear. The NFA isn't going anywhere, at least not yet. But here's where it gets complicated. Congress recently removed the actual tax on suppressors effective January 1, 2026, under the so-called Big Beautiful Act. That creates a strange contradiction. The NFA is supposed to be a tax and registration scheme, but once the tax is gone, all that's left is a registry. Even the Supreme Court has acknowledged in past rulings that the NFA rests on Congress's taxing power. So, if the tax is dead, can the registry survive? That's the million-dollar question, and the Fifth Circuit may have just set the DOJ up with an argument to keep it alive anyway. Gun rights groups aren't taking this lying down. The Firearms Policy Coalition, Gun Owners of America, and the Second Amendment Foundation have all signaled that they're preparing new challenges. They're looking for plaintiffs who can build a stronger record, showing exactly how long the process takes, how the costs add up, and how the delays effectively block ordinary Americans from exercising their rights. The Peterson case wasn't the perfect vehicle, but the next one might be. And let's not forget, suppressors aren't some fringe accessory. They're legal in 42 states. They make shooting safer by reducing noise and protecting hearing. They're widely used for hunting and sport shooting in Europe, where regulation is far lighter. The only reason they carry such a stigma here in the U.S. is because Hollywood branded them as tools of assassins, and Congress used that fear to justify the NFA nearly a century ago. The reality is, suppressors are safety devices, and yet, thanks to this ruling, they remain locked under some of the harshest federal regulations in existence. At the end of the day, This isn't just about one man's homemade suppressor in Louisiana. It's about how far the government can stretch Supreme Court precedent to keep outdated laws alive. The Fifth Circuit took Bruen, a case meant to expand freedom, and twisted it into a tool for justifying more restrictions. That should worry every gun owner. Let's be honest, calling the NFA a shall-issue system is smoke and mirrors. A true shall-issue permit is supposed to be quick, predictable, and objective. What we have under the NFA is slow, expensive, and deliberately designed to discourage ownership. An 8-month backlog and a $200 tax stamp aren't just minor inconveniences. They're barriers. And barriers are exactly what the Second Amendment was written to protect us against. Critics like to say suppressors are dangerous, but the data doesn't back that up. According to ATF's own reports, crimes involving suppressors are vanishingly rare, less than a fraction of a percent of all federal firearms prosecutions. Meanwhile, millions of hunters, sports shooters, and responsible citizens use them safely around the world. To keep treating suppressors as if they're some exotic threat is pure politics, not public safety. And here's the real danger. Now that the Fifth Circuit has blessed this scheme, other courts may copy the reasoning. That means the burden falls on groups like FPC, GOA, and SAF, and on us, the gun-owning community, to keep the pressure on. Because once a bad precedent sets in, it takes years to undo. So where does that leave us? The door isn't closed forever. The court itself admitted that a better case, with hard evidence of abusive wait times and costs, could succeed where Peterson failed. That's the fight gun rights groups are gearing up for right now. And if the tax really is gone in 2026, the entire NFA could be ripe for a constitutional challenge. For now, though, the message is clear. Suppressors remain trapped under federal regulation, and unless the Supreme Court steps in or Congress finishes what it started, the NFA's chokehold on these safety tools will continue. So here's the bottom line. The Fifth Circuit just gave the National Firearms Act new life by calling its suppressor restrictions presumptively constitutional. That's a dangerous precedent, one that could echo through every future challenge. For now, suppressors stay under the same outdated system, taxed, tracked, and delayed, while millions of Americans are told to wait, pay, and comply for a right that shouldn't require government permission in the first place. The fight isn't over. With the NFA's tax gone in 2026 and new lawsuits on the horizon, there's still a path to strike these restrictions down. But it's going to take the right case, the right plaintiffs, and a lot of persistence from gun owners and advocacy groups alike. Now, I want to hear from you. Should suppressors be treated like any other firearm accessory, bought over the counter with no special tax or weight? Or do you think they belong under the NFA? Drop your thoughts in the comments. And if you found this breakdown helpful, make sure you like, subscribe, and share so more people stay informed. We'll keep tracking these fights and bringing you the analysis you won't hear anywhere else. Until next time, stay informed, stay ready, and above all, stay sharp.